Welcome back to the Armchair Attorney Podcast. I'm your host, Matthew Leffler, the Armchair Attorney, a real-life lawyer who has the privilege to work in the transportation, supply chain, logistics space. It's something that tends to be controversial from time to time. Regulations are everywhere. And with the end of the year approaching, we need to look back and see what's been going on, what's happening in this incredible supply chain that we all find ourselves in and unable to escape from. Before we get to my guest, Brandon Wiseman, and if you follow the program, you've seen him before. You see his stuff online all the time. He is a phenomenal resource in the space of transportation, compliance, and generally a DOT guru. We'll have him here in just a moment. But I got to start off, as I always do, by thanking the folks who help make this whole thing possible. And I am so grateful for those who have supported us through this journey. One of those happens to be my good friends over at DAT, Dial a Truck. Since 1978, DAT has helped truckers find profitable loads, getting from point A to point B and occasionally point C. And brokers more recently. The DAT is part and parcel to the transportation business. How you find freight, how you understand the way this industry is behaving and market conditions. DAT's got the data, and we've been partnering with DAT for the better part of a year or so. Phenomenal organization. And if you don't have a DAT account, well, you can get one very simply. In the podcast show notes, there is a link. If you follow that link, you will get 10% off any DAT subscription for 12 months. What a deal. What a deal. Well, we are always grateful for DAT, Dial a Truck, sitting on the pallid bust of Apollo, somewhat adjacent to my chamber door. And of course, our friends over at the Floating Disembodied Head. Floating Disembodied Head, ask for it by name. It's very important, very helpful. Thank you, as always, for tuning in. Look, this is an interesting episode because I love talking to lawyers. Some of my favorite people are lawyers. And you might say, well, Matt, are all lawyers like that? Not necessarily. We're kind of an interesting, eclectic group of men and women who find ourselves trapped to an extent in the law. Now, there's been a lot of stuff happening in the Federal Motor Carrier Safety Administration, the regulatory body that governs the brokers and the motor carriers and all the folks that are moving things. Some of those recent proposed rules we're going to talk about today, things like broker transparency, speed regulation, and some of the stuff that's actually happened already. For example, the clearinghouse. I don't know nothing about this. So I reached out to the guy who knows a thing or two about a thing or two, Brandon Wiseman. He is the CEO of TruckSafe. It's a consulting organization helping motor carriers stay compliant in the world of moving freight safely, on time, and undamaged. He is a partner at the Childress Law Firm because he's a real-life lawyer who does real-life legal work. And then he also is the founder of a company called eRegs. This is electronic regulations you can see and make notes on. He is a tireless advocate for the industry. The amount of content that Brandon puts out any given week is phenomenal. It is a master class in supply chain rules and understanding how you do this business consistently and stay compliant. It is not an easy business. So without further ado, let me bring in my good buddy, Brandon Wiseman. Brandon, how are you?
Hey, Matt, pretty good. I thought we were just lawyers playing that role on podcast, but we're real life ones apparently.
So the student loan payments that I make every month certainly indicate
I'm with you.
that I am in fact who I purport to be. I graduated in 2010, so I've been a lawyer for nearly 15 years. How long have you been practicing at this point?
14.
There you go.
So 2011.
Oh my gosh, you're just a kid. Oh, when you get to be my age, Brandon, you have no idea how difficult things get. You have no idea. So for those who don't know who you are, who is Brandon Wiseman? What do you do? How do you help this industry?
I'm a trucking lawyer, and so that has always been my thing in this career. I started off at a law firm in Indianapolis, and that law firm specialized in transportation law. So we represented.
That was Scopelitis, right?
It was Scopelitis, yeah. And we represented, I think, 95 of the top 100 carriers in the country, and so got a lot of good experience there working with large fleets on DOT safety and compliance specifically. So did that for many years, and then broke off on my own. 2021, started a small law firm with a partner of mine, and then TruckSafe, which was kind of my brainchild. I wanted to put together and deliver a bunch of content on better understanding the DOT safety regulations, which in my view didn't exist all that well. And so I started doing that through TruckSafe, and we continue to do it.
What I love about that is like one of the challenges. And so for the folks who don't know who Scopelitis is, and you mentioned them as one of the biggest law firms in our space, representing 95 of the top 100 motor carriers. Like this is the training ground for the best lawyers in the business. Like that is the place to start. And one of the things I've always found on the law side is like, you're always trying to correct the mistakes that have happened. Like I would rather not come and unmess up the situation. Like how can I be more proactive? And that I think kind of gives a genesis for what you're talking about with TruckSafe is how can we be on top of the regulations and help people put the best practices in place before something terrible happens.
Yeah, I mean, that's the message I have been preaching for 14 years, my entire career. And in fact, I'm coming over from another podcast. I just finished up another podcast, and we spent the entire time on that podcast talking about the importance of being proactive on these issues specifically. Too many carriers and drivers are reactive in this area. And so we don't hear from them until something bad has happened, whether it be a DOT audit or a bad accident. And unfortunately, at that point, there's only so much you can do. Had you just spent a little bit of time and effort ahead of time to understand your obligations under these rules and put in the processes and policies that you need to have in place, then maybe you could have prevented this situation. More than likely, you could have prevented this situation to begin with, but here we are. So, yeah, I mean, I can't overstress how important being proactive when it comes to DOT safety and compliance is.
Well, I love that because like my world is preventative maintenance. That's why I've lived and breathed. Like, how do you maintain your equipment or maintain your contracts in a way that it's not going to have that unplanned event that you act like it's you're surprised, but really these are the inevitable things. So, what is a DOT intervention? Like, what does that look like for somebody?
Yeah, so first of all, DOT, as many will know, FMCSA specifically, is a pretty small agency, and so they've only, I think, got 1,000 employees roughly, and they're charged with regulating over 800,000 truck and bus companies in the U.S. at this point. And so what that means is that they just don't have the resources to go out and randomly audit carriers. Mm-hmm. And so how do they do it? They have to do it through a system of prioritization. They are prioritizing the worst offending motor carriers according to the data that they have access to then target for enforcement, usually in the form of an intervention or an audit or compliance review. And so, yeah, it's carriers who find themselves with high CSA scores. That's the primary prioritization system that the DOT uses. So folks are familiar with CSA scores, right? These are the scores that all regulated carriers have, and they are based primarily on your roadside performance. So as your trucks and drivers are getting stopped and inspected, those violations that you incur in those inspections are filtering into the CSA system and impacting your score. As you perform worse relative to your peers when it comes to roadside inspections, that's when you have a target on your back for an audit.
I want to pull that thread of as it relates to your peers, because this is the thing I find so fascinating. Hours of service violations, driver violations, I feel have gone down to an extent after the ELD mandate. We have some speeding issues that kind of happen, but like I still get thrown a curveball when I talk to people about vehicle maintenance. And so the national out of service rate in this industry is like 21%, which is to say 21% of vehicles that are inspected, if you look at them and go, that is not safe under any system. How should we think about something like that?
Yeah, I mean, a couple of different points. Number one, yeah, you're right. I mean, the national average for vehicle out of service, I think, is 21.7%.
Yeah,
it might be over 22% now. Yeah, so a crazy number of vehicles driving down the road are, if they were to get inspected, are going to be prohibited from continuing to operate because of some serious safety defect. Now, oftentimes those are things that are easily corrected roadside. So
Yeah.
maybe you've got a turn signal out or a headlight out or something like that. But many times it is not something quickly
The tire
fixed.
tread depth, it's brake lining.
That's right. Brakes, lights, and tires, right?
That's
BLT.
right. The BLTs, they're delicious on a sandwich, but they're devastating in a commercial vehicle.
Bad news if you're a fleet. Yeah. So, those are the common suspects that lead to those issues. And it's a significant problem. And for many reasons. Number one, as we've already talked about, as you continue to have more and more of those types of maintenance related violations, it's going to cause your vehicle maintenance CSA score to tick up, and then you're going to be on the radar for a potential intervention. But more than that, it causes issues in all kinds of other areas. A lot of times the shippers and brokers, your customers, are looking at that data and they're using that to determine whether they want to do business with you or not. And so if you have a vehicle out of service rate that exceeds the national average, for example, then you are less attractive as a potential partner for that type of business because of the skin that those folks have in the game. And then also certainly on the highway accident front, if you have poor safety metrics, including vehicle maintenance out of service rates, then that for sure is going to be paraded in front of the jury. God forbid you get involved in a bad accident, and it is likely not going to play out well for you in that context.
Absolutely. We have some great comments in the chat. I usually don't bring up the comments, but Lauren Began, she's another lawyer. So whenever a lawyer jumps in, I want to say, I appreciate you. She's absolutely right. And same with your point earlier about being proactive on compliance. You're not able to say, I don't understand the rule, that's why I didn't comply with it. Like, ignorance to the law doesn't give you a way to escape it. You're still held to the same standard, even if you don't understand the rule. And I think that's a really good point I want to kind of segue to, because I have heard there's a story going on about the clearinghouse changes, and I don't know a lot about that. Can you kind of tell the audience a little bit, what have we seen happen? What does it mean? What should we think about? Is it 100,000 drivers are now out of the pool? What's happening?
Yeah, I mean, something has happened, but it's not as dramatic as some will make it out to be, and I think they just misunderstand what exactly happened. So it's called Clearinghouse Phase 2. This took effect November 18th of 2024, and this actually kind of closed a gap that we had that had been lingering since the implementation of the original Clearinghouse Phase 1 in 2020. So folks who aren't familiar with the Clearinghouse, first of all, you need to make yourself, get yourself up to speed on the Clearinghouse. I still encounter so many carriers that don't know what the clearinghouse is, and if you use CDL drivers, you should be using the clearinghouse, and if you're not, you're exposed pretty significantly. Clearinghouse is a central repository for drug and alcohol testing data, violation data for all CDL drivers in the U.S. And as an employer of those drivers, you're supposed to be using the clearinghouse to make sure you don't have drivers out there operating on the roads who are prohibited from operating because of a drug or alcohol testing violation. And so that system has been running for about 5 years now through a system of reports to the clearinghouse and querying the clearinghouse as you're hiring these drivers. And so Clearinghouse Phase 2 in November closed a gap, and it essentially requires the state driver's licensing agencies to start leveraging the clearinghouse when they are engaging in CDL transactions. So as they are issuing new CDLs or upgrading existing CDLs, they are supposed to query the clearinghouse and see if the driver who is there before them is in prohibited status. And if they are in prohibited status, then the state driver's licensing agency is supposed to downgrade that driver's CDL or downgrade it, because it doesn't make sense for them to have a CDL if they're prohibited from operating commercial vehicles, right? So it's been a gap because many states haven't been doing that. Some have voluntarily done that, even though they weren't required to.
So would it be the case, I'm trying to think of the example, like someone's driving interstate, they pop on a random panel and they have to leave that motor carrier. Are they then going to drive intrastate, and so they were able to continue being a commercial driver, but just in the state? But or how is this actually being run?
So something a lot of folks don't understand is that when it comes to CDL rules and drug and alcohol testing rules, they apply to interstate and intrastate drivers. It is one of the few areas of the Federal Motor Carrier Safety Regulations that apply both to interstate and intrastate drivers. So so those drivers that get put into prohibited status in the clearinghouse aren't even authorized to operate intrastate, and also they aren't even authorized to operate a vehicle that doesn't require a CDL for commercial purposes.
Interesting.
So but here's where it comes up. So, and this gets back to people being dramatic about this. These 188,000 drivers that are in prohibited status in the clearinghouse, they are in prohibited status, meaning they have always been prohibited from operating any commercial motor vehicle. And so the fact that the states are now required to downgrade their license doesn't somehow now magically do something more than what was already supposed to have been.
So they weren't in the driver pool anyway at this point.
They shouldn't have been, but
Okay.
the reason it's been a problem is the reason I already mentioned, which is that so many carriers still aren't even using the clearinghouse that should be. So they should have been tipped off to the fact that they couldn't use these drivers had they been doing the required queries through the clearinghouse and seen that they were prohibited. And so I think the idea with this phase 2 was to give them even a little bit more of a nudge and say, hey, not only are they in prohibited status, but now when they come to you, they're not even going to have a valid CDL. So, but again, if you look at the carriers we're talking to at this point, if they weren't doing the clearinghouse queries, are they really checking the CDLs to see if they've got valid CDLs? That's the question. And so that's what's changed with the clearinghouse.
Do you think we'll see less violations for people operating commercial vehicles that don't have it, or is it going to be just kind of the same as we've seen before?
No, it'll still so the clearinghouse publishes its statistics monthly of how many drivers are getting drug and alcohol violations and being put into prohibited status. We've seen that rising at a pretty steady rate over the last 5 years, and I anticipate we will continue to see it rising at the same rate.
Do you think we're going to see hair follicle testing become more ubiquitous in the industry? Because that's been another point of contention on the drug and alcohol side of things.
No, I don't see it on the horizon anytime soon. I mean, various industry groups over the years have petitioned for the FMCSA to implement hair follicle testing, including a lot of safety groups, including
and big motor carriers who'd like to use it already.
Yeah, who are using it voluntarily. Now they're using it for non-DOT testing purposes, which is how they have to use it. And so FMCSA has been hesitant for whatever reason to push forward with that, and so it's not on the agenda for any time soon. The one thing I wish that they would do, if nothing else, even if they don't recognize hair follicle test as a legitimate DOT test, I think they should at least accept positive hair follicle test results into the clearinghouse.
Yeah, that's an interesting point. So, like, if you fail a hair follicle test, you don't get to take that driver and say this person cannot drive through the clearinghouse. The clearinghouse is gonna be like, that's not a test we require. We're talking about the 5-panel urine test, if I'm not mistaken.
That's right. Yeah, I mean, if you're a large carrier that's using hair follicle testing now and a driver tests positive on that hair test, you cannot report the results of that test to the clearinghouse. And so you could see the gap that leaves, right? Because then that driver leaves your employ and they go apply at a new carrier, and that new carrier, even if they're running clearinghouse queries, is not going to see that result. And so unless that driver volunteers that information to that new carrier, which they have no interest in doing, then that new carrier is going to be blind to that fact, unless they somehow find out from the previous employer.
So we have an administration change coming. I'm sure you've heard about this. There was initial rule-making process around speed regulation. So this idea was, I'll kind of simplify it, and you can correct me as I kind of explain this, but ELD mandate happens. The goal was to provide better safety for the industry. And one of the things we've seen happen with the ELD mandate is there's less hours of service violations, maybe, but we've seen an increase in bad driving behavior, people speeding and that kind of thing. And so this new kind of push has been, how do we solve that? And big motor carriers for a long time have been doing speed regulators. And so we had the FMCSA propose a rule initially at 68 miles an hour. They retracted that number like right away. And now we're still kind of wondering, first, do you think we're going to see a speed regulator, or do you think it's going to go away with the new administration? What are your thoughts on that?
It wouldn't surprise me at all if this continues to get kicked down the road. So this was originally proposed as a joint rulemaking between FMCSA and NHTSA in 2016. And it has been pushed down the road since 2016. And the latest I saw on this, it's still on the agenda. In fact, FMCSA came out earlier this year, 2024, and said, hey, we're still thinking about doing that. The next thing that would happen is that we would get a supplemental notice of proposed rulemaking.
Yeah.
So you're right. There's a notice of proposed rulemaking out there, but that notice of proposed rulemaking does not set what the actual speed would be limited to. You're right. They came out with a notice, and I think they accidentally put 68.
Yeah, they telegraphed what they were thinking. And people were like, do not do that.
So, yeah, the joke is I think that person got fired from the FMCSA as soon as that happened because they immediately retracted it. But the point is, it's still on the agenda. I think the last I saw is they're looking at May of 2025 as the next time that they may get back to this subject. But it wouldn't surprise me at all based on the history if we, particularly now with an administration change and a Republican administration where we tend to see, kind of a rollback on federal regulations, it wouldn't surprise me at all if we see this kick down the road even further.
This is why I find that particular rulemaking so interesting, because if I'm not mistaken, the ATA is in favor of this rule. And there's a lot of reasons why you should go slower as a motor carrier. Better for your fuel, better for your tires, better for maintenance. But if you're paid by the mile, it really is we're going to take money away from you. And so I'm curious, if we see a Republican administration come in place and you have presumably the ATA is the one fighting to have the rule, the OIDA folks are fighting against the rule, do you see this happen? That's why this speed regulator is such a hot button topic.
Yeah, it's an interesting one for the reasons you mentioned because remember, Trump was already in office in 2016 when that was first proposed, and it never went across the finish line. And so will it happen this go around? Because you're right. A lot of large carriers that have been using speed governors voluntarily for many years are generally in favor of it. And so, there probably is some kind of a push to the legislators and the agency itself for this type of rulemaking. But it didn't happen before. Will it happen again? I don't have a crystal ball, so hard to tell.
Well, we're going to get your crystal ball out because we're going to talk about probably one of the most exciting and interesting proposed rules that I've seen so far. This is on broker transparency. So FMCSA, Federal Motor Carrier Safety Administration, from my understanding, their primary objective is safety. And then we have
What would make you think that?
I have no idea. So 371.3, this is this rule that says people who are part of a broker transaction can have access to these records. There is a long history of this rule from different reasons, but this rule gets announced. What are you thinking? Have you thought about this rule? Have you talked with your clients about what it might look like for them?
Yeah, as you and I have talked in the past, I try and stay out of this area as much as I can. I work primarily on safety and compliance, and for the same reason that I stay out of this area, I tend to think FMCSA should stay out of this area because safety is in its name, right? This goes back. Broker transparency laws, regulations that are on the books, they are holdovers from bygone era of when trucking was heavily regulated from a commercial standpoint. Everybody has probably heard the term deregulation, which happened in the late 80s and early 90s. That is when Congress saw fit to deregulate the commercial aspects of trucking. Obviously, we still have a highly regulated industry from a safety standpoint. We still have the Federal Motor Carrier Safety Regulations, and that's where we still see in those regulations some holdovers from when the commercial aspects of trucking were regulated, including regulations that ostensibly govern the relationships between players in the industry, shippers, brokers, and carriers. And that's where you see these transparency regulations. And to be honest with you, since deregulation, these regulations have been on the books, but there just have been no teeth to them.
Yeah,
there has been
exactly
no interest by the FMCSA in enforcing them because their primary mission is safety nowadays. And so they don't even have, as we've already talked about, they don't even have the manpower to effectively tackle the safety related issues that they are charged with tackling. So now we're going to ask them to jump in and enforce commercial regulations that Congress doesn't even see fit to regulate that part of trucking anymore. I think it's missing the mark. And so you're right. I mean, FMCSA has, I think they've gotten worn down from the amount of blowback that they've gotten on this issue from the carriers in this case. And so they came out with a notice of proposed rulemaking on broker transparency. But even if we get those rules pushed through, I don't have much confidence that they're ever going to be enforced. So.
I think that's a great point, because like I started to go through some of the comments to that rule, and there's like 700 comments, or some maybe 800 at this point, and like there's these ones that you can clearly tell are done by Chat GPT. They're all identical. And it's like, oh, this is phenomenal. I think the point I'll say, and you're a lawyer, so you get this better than most people. The FMCSA in that proposed rulemaking specifically said, we are not going to deal with the waiver issue. So part of this relationship between a broker and a motor carrier is this agreement that they both sign. And the brokers almost to every single one of them that I've encountered, force the motor carrier to waive the right to those records. And FMCSA said, look, we don't have even the authority to make the waiver go away. So unless Congress acts, we can't make the waiver. So I think, to your point, it's a distinction without meaning. They might make some proposed rules, but if you've already waived those, you still waived them. That's the end of that story.
I mean, yeah, that's deregulation in a nutshell, right? We are going to leave it to the market to figure these issues out, and private contract, and that's how we've been operating for the past several decades when it comes to these commercial disputes. And so I think that's how we should leave it. And I know there are, as you said, there are several others, including large interest groups for the brokers out there that have filed comments to that effect in the docket, or they will be in the near future. And I suspect that will have significant sway in that rulemaking. So.
What I'm excited for, Brandon, and this is, again, lawyer to lawyer, I really hope we get to see Chevron and Loper Bright be talked about. So like the FMCSA has their enabling statute. It has the specific purview of what they do. And to your point, their mandate's safety. Their mandate is not the commercial aspect of these deals. And I would love to see someone like the TIA or others challenge it fundamentally and say, under Loper Bright, there's no more Chevron deference. We say you have no authority. And then watch that unfold in front of us. I hope we see that. I don't know if we will.
Yeah, so I've seen TIA's statement on it, and they certainly reference that these are holdover commercial regulations for which there are no teeth to enforce. I haven't seen them tie it directly to Chevron deference, but I know you and I have talked about that on past shows, and it's certainly an interesting way to look at it as well.
I think we're seeing the same with the EPA stuff on the trucking regulations, like new emission standard thing. Yep. We'll see that same kind of challenge. Mm-hmm. What are some of the rules that are in place or have happened this year that we don't really talk about much? Like what new things have you seen happening?
It's been a relatively slow year from a rulemaking standpoint. The clearinghouse development was certainly the most prominent one lately. Earlier this year, and even back into late 2023, we saw the agency propose some changes, primarily on the enforcement side of things, and namely with respect to how it issues safety ratings to motor carriers. Very early in the rulemaking process, it's an advance notice of proposed rulemaking that they published, I think, earlier this year or late last year. But anyway, that would, from what I understand, pretty significantly shake up the way that we issue safety ratings: satisfactory, conditional, unsatisfactory, the three-tier rating system that we've had in effect for decades at this point. That would be a substantial change, potentially, if the agency pursues that. Where I think they're probably going with it is folks in the industry, or carriers in particular, will know that for years there have been challenges to the FMCSA CSA system and how it scores motor carriers and issues the CSA scores. And so the FMCSA has been working through that over the years, and has commissioned an independent study of the effectiveness of that program and whether they need to make potential changes of that to be more fair in the way that they rate motor carriers. And so we saw FMCSA FMCSA proposed some changes to the way that it's going to score carriers in the CSA system, and I think that once those changes take effect, then the FMCSA will probably push through with these potential changes to safety ratings, and maybe potentially tie a carrier safety rating, at least in part, to their CSA scores, which would be a substantial shift. It's something that they had originally proposed in 2016, I think, that eventually got shot down because of the problems with the CSA scoring methodology. But now I think they're thinking, hey, if we fix the CSA scoring methodology, I think it's up for debate whether these changes would fix the scoring methodology.
Interesting.
But regardless, I think that's kind of their mindset is we're going to implement these changes, fix the CSA scores, and then we will start to tie a motor carrier safety rating, which is essentially saying we're going to tie their license to operate, because the implications of a unsatisfactory safety rating is that your whole fleet gets shut down.
Yeah,
and
exactly.
So if we're going to start tying those to CSA data, essentially roadside inspection activity, and start shutting carriers down based on their roadside inspection activity, that would be a sea change.
Do you think they have the resources for that, or they need to like double their budget, double their agents to be able to actually make something like that?
Well, that's the whole thing, right? Because right now, to get a safety rating, carriers have to go through a full compliance review. And so the whole problem with that system is that upwards of 95% of the regulated carriers in the country don't have a safety rating because the DOT doesn't have the resources to do audits. So one of the driving factors for that potential change is that if we tie it to roadside inspection data, then we can leverage our whole network of state law enforcement agents who are doing these roadside inspections and generating all of this data about compliance roadside. Then we can leverage that and start putting more and more carriers out of service completely, their entire fleet, based on that available data, rather than having to tie so many resources up in doing physical compliance reviews.
Interesting. Well, I love how like we talk about like the rulemaking process and this idea of an advanced notice of proposed rulemaking. For those who aren't lawyers, like this is the kind of way an agency says, hey, we have an idea. We're not going to propose anything, but we'd like you just to tell us what you think about this. Yeah. And then they gauge what people say. And then maybe that advance notice moves to a proposed rule. And then you get to comment on the proposed rule. And then you have a final rule. And it's this really interesting thing. And I want to use that kind of analogy to talk about the thing that you and I talk about every single time we're together, and that's autonomous trucks. So like we have been watching and we've been waiting to see, will they come up with level 4 and level 5 automation like rules? And for those who don't know, level 4 automation is the remote operator. Level 5 is a remote assistant. It means that there might be a human involved with the transportation, but they're not controlling the machine. Do you think we'll see anything now that we have Elon Musk really kind of talking to Donald Trump? Like, is there a path? Maybe we see the robots rise up?
I think so. And we need a regulatory framework for that because we have nothing. Yeah. Right now, there are no federal regulations governing autonomous trucks. And so what we have is an advance notice of proposed rulemaking. I think it's a few years old at this point. That's where right. The FMCSA said, here's all the questions we want to get answers to before we push forward with regulations. And yeah, I think it's one of those things that's always on the agenda for the FMCSA to tackle, but I don't have any sense of when they would push forward with a notice of proposed rulemaking. I don't know that they know when they would push forward with that, but certainly these operations are on the horizon. I mean, just go down to Texas and you will see these trucks operating on the highways.
That's right. You know, they'll have a safety driver.
They'll have a safety driver with them, but largely operating autonomously. And so this is already a reality that we have to deal with. And the federal regulations are just going to be behind the 8 ball on this.
So often our technology advances faster than our ability to regulate it. And so we end up saying, okay, now we got to figure out a solution. What I like about the autonomous truck, at least as I understand it, is that it's not going to be the same way we look at commercial trucks today, where 80% are safe and 20% are unsafe. I think an autonomous truck has to be 99, maybe 100% vehicle maintenance compliant for anybody to allow that thing on the road. And if that's the case, like I welcome our robot overlords. I think that's a great idea. And it would presumably finish the work that deregulation started all these years ago. How do we control the cost of labor? And robots are a pretty effective way to do that.
Yeah, I think we did, and we've talked about this before. I think we kind of, so right now we're in a world where a lot, not all, certainly not all, but a lot of the violations that we see roadside, and then also a lot of the contributing factors to significant accidents are driver behavior type issues. Just look at ATRI's study on nuclear verdicts and what issues in those cases tend to result in nuclear verdicts. Most of the issues on that list are driver behavior type issues, fatigue, speeding, all of those types of issues. But as we transition to autonomous trucking, I think the bigger issue becomes vehicle maintenance, because you don't have the driver in the seat anymore to worry about hours of service or drug and alcohol issues, or
it's human beings inspecting those sensors to make sure they're still working. Those wiring harnesses are still functioning correctly.
Vehicle maintenance becomes the focus more so than the driver issues.
Wouldn't that be an incredible sea change? I remember I was at an IANA business meeting, and there's a regulator from the FMCSA there. I was like, well, what do you think about the out of service rate? Like, is this an acceptable number? He's like, well, we believe that it's the drivers that really drive the accidents. The vehicle maintenance may be indicative of the carrier's, ability to operate, but it's not what causes these accidents. It's the driver that does. And it's like, well, maybe that's the case, but man, I don't feel happy knowing that 20% of all the vehicles that are on the road now, if you looked at them, would go like, that's not safe.
I mean, to their point, though, so one of the I mentioned potential changes to the CSA, the way that we score motor carriers. One of the major changes to that system that is going to come into play here in the next, I think, several months, is that they are going to split out the existing vehicle maintenance category into two subcategories. One is going to continue to be called vehicle maintenance. The other is going to be called vehicle maintenance driver observed. And what this is going to do is it's going to break out violations that the system thinks could have been caught had the driver done a thorough enough pre-trip inspection. Those are going to be in the driver observed category, whereas the standard vehicle maintenance category is going to be the issues that were more latent, that couldn't have been caught even if a driver had done a thorough enough pre-trip inspection. And I think that's a good change, because what it's going to show us is that carriers that struggle in the driver observed category, probably the root cause for their violations is not holding their drivers accountable to doing thorough enough pre-trip inspections. And so I think that will go a long way to maybe getting control of that and hopefully driving down the vehicle out of service rate. I mean, obviously we'll have to wait to see how that plays out, but it could very well start to do that.
I mean, I can think of like a tire tread depth. That's a great example of what a driver ought to be able to catch, unless it's covered in snow and maybe other things would make it difficult. You mentioned nuclear verdicts, and there's a lot of them these days. We just saw earlier this week the oral arguments in the Supreme Court of Texas around the Werner Enterprises case. And for those who haven't been following the case, I'll kind of just give a little rundown of the facts. There is a truck driven by Werner Enterprises. It is snowing. It's a winter advisory. They're going below the posted speed limit, about 50 miles an hour. And they never lose control. They have, the truck and trailer are well maintained. The trainer for the driver is asleep in the berth. So it's the driver who's driven this lane. In the opposite side of the highway is another driver in a passenger vehicle. It's a guy driving, a woman, and then her 3 kids. They're going about 60 miles an hour. They hit some black ice. The passenger vehicle spins out, crosses a 40-foot long divided highway median. And within about 3 seconds of that spin out, it impacts a truck operated by Werner, and 1 kid dies. 2 kids get severely injured. The passenger, the woman, she gets very injured too. And then it goes to trial. And at trial, it's found that Werner hits for $100 million. They say Werner is 70% at fault. They say that the driver for the passenger vehicle, 16, the driver for Werner itself, the guy, Ali, he was 14%. It gets upheld on appeal. It goes to the Texas Supreme Court. What do you tell a motor carrier when they learn about this case? Like, have you had any of your clients, hey, what should I think about this?
Yeah, every week I have clients ask me, what can we do to not end up in that similar situation? And it's cases like that make me question this career that I've taken, because it's like, I could have told you to do a million things, and none of them would have kept you out of that. Save one. I mean, there's one thing I think. There's one lesson I think fleets can take away from that case. But then you start to look, and I'll mention that in a minute. But then you start to look at cases like the Wabash Trailers case.
That's another case,
like a $400 million case against Wabash, where they got sued for a passenger vehicle underwriting one of their trailers that had been manufactured several years ago.
And 20 years ago. It was a 2004 trailer.
A 2004 trailer with an underride guard on the back that was compliant with the standards in effect at the time of the trailer's manufacture. But the underride guard failed, as I understand it, and the car underrode the trailer and resulted in significant injuries, if not fatality.
Two fatalities. 55 miles an hour. They hit the back of that trailer. Both those driver and the passenger died instantly. It's insane.
But that one is even more boggling to me, because it's like, what could I tell a trailer manufacturer that would have kept them out of that lawsuit? The trailer was manufactured in a way that was compliant with the standards in effect at the time, and so it makes our jobs particularly difficult. It puts carriers in a position of feeling like there's really nothing we can do, but kind of going back to the Werner case, my advice to clients coming out of that case is, the one thing involved in that case that I think is kind of the issue here is Werner having written policies in place pertaining to when driver trainees could be driving, in what weather conditions they could drive and couldn't drive, and when the trainers are supposed to be there observing the trainees and driving. And it seems like, at least it was alleged, I believe, that Werner had not followed its own policy with respect to those issues. And so that's a takeaway from that case, right? I mean, if you're going to have policies as a motor carrier that govern your operations, then you better be sure that you're following your own policies, because you're essentially setting your own standards by which you are going to be judged. And so it definitely warrants dusting off your policies on some frequency, understanding what you have written in those policies, and making sure that you're following your own policies. So I think that is certainly a takeaway. But then, looking at cases like the Wabash case, it's like, at some point you just throw up your hands and you're like, there's nothing I could have done that could have kept me out of this lawsuit. So that's my initial take on them.
It's interesting. So like on the Wabash case specifically, the idea of a product liability case being brought against a manufacturer of something that was made to the federal specifications and then being found liable is mind-boggling. I've talked with trailer manufacturers and big fleets. They're like, do we need to take all of our trailers off the highway? Because to your point, the standard at the time that trailer was made was 30 mile an hour to prevent an underride. It got changed later on to 35 miles an hour. But that car that hit the back of that Wabash trailer was going 55 miles an hour. No one crash tests anything for 55 mile an hour for underride, which means there are 5 million trailers in the United States that probably aren't able to meet that standard. Do you pull them off the highway and modify them? And my advice, this is not legal advice. Don't take legal advice from a podcast, even if there are two fairly accomplished lawyers here, is that you really need to wait and see what happens in the appellate process. Yeah. I think the appellate process in the Wabash case will be very instructive. There is tort reform in Missouri. That number will come down from 462 to probably 70, but still, we need to watch that thing evolve. For the Werner case, this is what is so striking to me, is that there is some regulations within Werner's own policies, but also some state regulations about if it's black ice, you should go slower. And it's debatable, right? About is the driver operating safely? Because he was going 50 miles an hour on, I think it was 70 or 65 mile an hour road, never losing control. As a professional driver, you're probably fine. And if anything happened to that truck at any time, they were going to be found liable, because essentially they're saying it's negligence per se, driving this thing when it's snowing. So as a motor carrier, do you just park your assets? Do you say, everyone slow down? It's an absurd outcome. But it's an interesting thing to kind of follow as we watch our industry get attacked again and again and again.
Yeah, and I think the other general piece of advice that I'm seeing myself give to my clients more and more often is, and it's kind of just looking at the mechanics of these cases and what the jury is essentially tasked with deciding. And it's something that I know you've preached and something I've preached. It's that when you're looking at this from a regulatory standpoint, the regulations are just the floor of what is expected of you. And so that's not the task that the jury is performing in a trial. They're not being asked just whether you followed the law or not. And then if you were, you get out of jail free card. That's not how it works. What they are tasked with deciding is whether you were acting reasonably under the circumstances. In most cases, that's what they're deciding. And so, what does it mean to act reasonably under the circumstances? Certainly, following the law is reasonable, but is going above and beyond the law reasonable? It may very well be the jury's determination that it's reasonable to do things that exceed your legal obligations. And so that's why I think it's also important, aside from just following the law, that carriers are keeping up with the Joneses, so to speak. In other words, looking around them and what are other carriers doing? What are my peers doing from a safety and compliance standpoint to try and prevent these accidents from occurring? And I'm not saying you have to adopt everything that your peers are adopting, but at least be aware of what they're doing. And as your resources allow for it, I think you start to implement the things that are becoming industry best practice. And that will go a long way in those cases for you to be able to argue that, hey, look, I was acting reasonably because I'm going above what the regulations require, and I'm keeping up with what others are doing to prevent these accidents to begin with.
What I love about that, and there's a couple of questions I'm going to bring up from the audience, but what I don't want to see happen is big, sophisticated motor carriers exit the business because it's too hard to comply, and then just have these small owner-operators, small fleets that have the bare minimum insurance, that have really no safety processes or procedures, and that is what we have to deal with as an industry. We really do want, at least from my perspective, sophisticated motor carriers that are asset-based, that have done this for a while, that understand the industry and make the effort to comply, as opposed to the other side, which is a bunch of people running around with the bare minimum insurance, poorly maintained vehicles that could ultimately just go bankrupt to make another company the next day.
This is the race to the bottom, probably.
Oh, absolutely. And we don't want that. But that in fairness, that's really what deregulation anticipated. But that's a side story. Rob Carpenter mentions on the Wabash case. This is something I always talk about this, and you can definitely opine on this. So the driver in the passenger vehicle in the Wabash case, that guy had a blood alcohol content twice the legal limit. And neither the driver nor the passenger had seatbelts on at the time. Why that was withheld from the jury is that this was not a negligence case. This was a strict liability case. When you talk about strict liability, it is about the anticipated use of the thing that was made. That case being the rear impact guard. It does not matter what the other injured person did.
It's not comparative.
Yeah,
fault.
It's about exactly. It's not a question of like, were you also negligent? It was a question of, was the anticipated use? It was to be preventing underrides. Should they have anticipated 55 miles an hour? That's what the jury said yes to. That's why it was withheld. I think as this evolves, if motor carriers start understanding this rear impact guard issue, maybe then there's a duty to replace or modify. That's a separate story. Now, this point Rob Carpenter makes about autonomous trucks, we're going to jump on this one for a bit, and we're going to actually bring in Lauren Began, is she still in the comments, about the ILA stuff. So here's his exact quote. I'm going to read this out loud. For autonomous vehicles, the bigger concern is the potential for hacking. The CAN communicator, or the OBD2 interface, with no one to control the vehicle but the person who has hacked it. So does TSA surface security standards currently for some coach operators extend to all, especially autonomous vehicles. Before I let you riff on this, Brandon, here's what I want to mention a couple things. One, our industry self-regulates for technology, for the FMCSA. So if you look at the ELD mandate, that is a mandate that says, just tell us you do this and you're fine. Like, our government is not testing the machines for what they do. And the ILA strike, which I anticipate January 15th, the fight that the longshoremen still have is autonomous vehicles. So if you want to see this innovation, how do you protect cybersecurity? That is the question I have. I would love to get your thoughts on that, Brandon.
Well, I think it's a question FMCSA has as well. We saw that in the ANPRM that is currently pending for autonomous trucks. And I think it is, as Rob said, it is, if not the most important question, one of the top questions that need to get resolved. And how that ends up playing out in terms of how do we make sure that that doesn't happen, I don't know. It could play out in any number of ways. Maybe we need to get other agencies involved in the process as well, particularly for the reasons you mentioned, Matt. If FMCSA doesn't have the resources to test the ELD devices, what makes us think that we're going to have the resources available to test the autonomous trucking technology? Probably not going to happen.
Absolutely.
I think we should, and we mentioned this when we've talked about this with ELDs in the past. Taking maybe a lesson from Canada, we don't do that often. But, the way that Canada handles their ELD mandate is they require certification of the ELD devices up in Canada. It's not a self-certification, but it's also not a government-specific certification. It's a third-party certification. Yeah. So the Canadian government has, as I understand it, contracted with certain third parties that can do the testing of the devices, and then they sign off on the devices as compliant with the technical specifications, rather than taking it through the process that we have, which is we rely on the manufacturers themselves to self-certify, and then maybe if enough instances of non-compliance show up in inspections, then the FMCSA swoops in and investigates, which turns out to be not a great system for catching problematic devices. So I think we could take a lesson from Canada in that sense and maybe consider, hey, if we're not going to have the agencies themselves police these things, maybe we at least consider contracting with a third party that is skilled in that activity and having them certify the technology.
I think you're exactly right. I think the FMCSA clearly understands there's an issue. So there's about 1,000 approved devices, self-certified devices, and then every, let's say, month or two, another or two devices get revoked. So there's like 200 devices now that have been revoked. Now, you, in a previous conversation, you clarified to me that sometimes the manufacturer themselves says, I want to revoke this one. I have a better one now. But there's also the ones that just simply do not comply. Yeah. And so I'm with you. I think the self-certification has to end. Now, as I look at the longshoreman issue, this is what I think is so fascinating. So you have 45,000 longshoremen across the East Coast and the Gulf Coast. They've agreed on the salary bump to 62% over the next 6 years. But the issue that they have not agreed on is automation. And that's automation from going into the gate, automation from the shunter trucks, automation from the cranes, all sorts of automation. And people are like, I don't want to see the longshoremen stop America. But a hostile foreign government certainly could if they could hack the systems. So I hope as we look at this automation issue as a more broad thing to think about is how do we protect ourselves from nefarious actors? I don't even know how you do that. It's like, you get the CIA involved, like Department of Homeland Security? I have no idea.
Well, you hope that there are people out there who are not you and I and actually have some idea of how to tackle these issues, and maybe they weigh in on it and come up with a great idea for tackling the issues. And as Jack mentions in the comments, I can see the comments here myself. These are hopefully things that experts will jump in on in the rulemakings that are pending for them to weigh in on and say, hey, we think we see this being done. You should consider this FMCSA to tackle those concerns. And that's how the system is. That's how the process is supposed to work. And so hopefully we can trust that the process will work out how it's supposed to.
All right, so we're getting close to the end of our hour conversation, Brandon. What are the regulations that you just wish you could get for Christmas? Like if you could just get a couple good regulations or regulations removed, I'm going to be open both ways. What would you like to see happen?
The one regulation that I wish existed that doesn't yet exist is probably just one, because I'm usually not a big fan of over-regulations. So if anything, it's probably some regulations that need to go away. But the one regulation that I wish did exist would be a mandatory continuous license monitoring platform. So folks in the industry, carriers, will know that there's a requirement now under the driver qualification rules that require you to run motor vehicle reports on all of your drivers once per year. right? So every 12 months, I got to run a new motor vehicle report on my drivers and make sure that they're still validly licensed, that they haven't had any disqualifying violations, that type of stuff. The problem with those is that they are stale the minute you run them, right? And so if I run an MVR on a driver today and he loses his license tomorrow, under the current regulations, I could be completely blind to that for a full year, and him out there operating a commercial vehicle without a license unless he tells me about it. And again, it's not in his interest to tell me about it. And so I think the solution to that is emerging. There's new technology that has been in place now for several years, but there are constantly new platforms out there that do this, is continuous license monitoring, where they will continually monitor the license status of your drivers. And this is a subscription product. A lot of fleets subscribe to this voluntarily, where not necessarily the minute, but at least within a few days or so, that of a driver losing their license, the system will automatically ping you and tell you that, hey, this driver's lost his license, and then you could pull them off the road immediately rather than waiting a full year. So I think that type of technology makes sense, and I think it could go a long way to minimizing exposure. So it's something that I'm constantly recommending to my clients, and I think it makes sense that we have something like that baked into the regulations as a requirement.
I have two regulations I would like to see happen, and one I'd like to see repealed. I'd like to see broker transparency repealed. I may not, but maybe we will if we see some litigation. I would love to see a higher minimum insurance threshold for motor carriers. You and I talk about this almost every time we get together, but to this day, the minimum insurance required for an over-the-road motor carrier is $750,000, established in 1980. It is too little, in my opinion. And I think that shippers today are starting to make adjustments and requiring higher levels of insurance, but I think a higher number would be good. What do you think about that?
I don't necessarily disagree with you that it would be good. I just am fearful for the fallout from that type of requirement, because as you and I have talked about, I regularly hear from my motor carrier clients who are struggling to pay the premiums for the minimum level of insurance. So how in the world are they going to be able to afford the minimums if we double that limit or whatever we're going to do to it? Yeah. So I think we have to get a handle on, first of all, and you see this in the rulemaking process, right? There's a whole regulatory or a financial impact analysis that has to go along with it. And so I would like to see what the expected outcome of that would be before we push forward with it. Obviously.
I just think if you reduce I think the barriers to enter this business are way too low. And I think the natural consequence of a regulation like that, controversial though it would be, is to reduce capacity. It would take people that can't afford this business and kick them out. And while that would be painful for many, many people, and it would ultimately cost American consumers more for everything that we buy, I think that's a legitimate thing to be focused on. The other one I want to get your thoughts on is, so the FMCSA today mandates one inspection a year, one commercial vehicle inspection. And other states like California have the BIT program. They do 4 inspections a year. I think they should do 2 inspections a year. What do you think about that?
I could get on board with that. Some kind of biannual commercial vehicle inspection. Again, I would like to see the numbers on it. For the fleets, it would be interesting to see. I think we talked about this in the past too. It would be interesting to look at the data for the California-based fleets that are supposedly doing quarterly inspections to see what their out-of-service vehicle out-of-service.
I'm sure it's just as bad as everybody else.
I was going to say, yeah. So if it turns out that the data shows that even increasing by 1 additional annual inspection or inspection per year would not improve the out-of-service rate, then what's the point? Right?
Yeah.
So, but yeah, I mean, I could get on board with it theoretically.
Well, that is that. We're at time here, Brandon. Where can people find more about you and the content that you create?
Trucksafe.com is our website where you'll find information about us. TruckSafe Live is our podcast that we do. Bring on great guests to talk about all kinds of DOT safety and compliance issues. So those are the places to find us.
Well, I appreciate you jumping on today, my friend. You have a great rest of your day. Get out of here. He's got to go. Ladies and gentlemen, that's the show. That's it for today. I am so grateful for the opportunity to come and deliver information to you and your family, your friends, people in supply chain. Brandon Wiseman is one of the best voices in the industry as it relates to compliance and regulation. brilliant guy, phenomenal content he creates on a regular basis. Check him out. We'll make sure to put his LinkedIn page and the website for his company in the show notes. If you find this interesting or valuable, please subscribe or do the thing the robot tells you to do. I am so grateful for my friends over at DAT Dial-A-Truck. Since 1970, 2 years before deregulation. These guys have been helping truckers find freight, find profitable things to move, and they got the data. Oh, so much data. And I had a chance to speak at DATCon earlier this year. It was a phenomenal experience. If you have a chance to attend DATCon, I highly recommend it. As always, thank you for tuning in. I hope the law is interesting to you as it is to me. Nothing better than hanging out with attorneys on a Friday afternoon, right? Right? Seems like it. Well, have a great rest of your day. Thank you as always. I appreciate you. Thank you for helping me do this thing that we continue to do. It's a lot of fun. Pallid bust of Apollo, somewhat adjacent to the chamber door. Have a great rest of your day. Take care.